48 District Court for County of Washington, pay attention to conversation. All those having business before the court draw near.
Could we have quiet? Go ahead, Mr. Allen.
The Honorable Judge Judge Simpson presides.
You may be seated. Ms. Lundy.
Morning, Your Honor. Ashley Lonnie for the people. Your Honor, at this time, people would waive any conflict between this honorable court and the Office of the Public Defender. The people do not believe that any conflict exists. They wish to avoid called out.
Thank you.
Good morning, Your Honor.
Yes.
Anna Mackey, requesting permission to practice under Michigan Court Rule 8.120 under Deputy Chief Public Defender Lauren Brown.
Permission to practice is granted.
Thank you, Your Honor. We waive any potential conflict between this honorable court and our office, and if a conflict were to arise, we waive that conflict so that this honorable court can hear these matters.
Thank you.
Thank you, Your Honor.
Court, for its part, also does not believe that a conflict exists either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Tomika Slip.
Hi, Mr. Simpson.
Good morning.
How are you?
I'm fantastic. And you?
I'm good. Did you have a good Christmas?
Yeah, a while back, I certainly did.
Me too.
And you?
I got a Christmas present.
Yay.
Somebody
got one.
saved me a teddy bear.
Oh, fantastic.
Yeah, I loved it. And cuddle with it every night. Its name is Brown Bear.
No relation.
Not going there.
And you still
relation.
got
All right.
that beautiful smile. You still got that beautiful smile.
Andrew Childers is written on behalf of
Lauren Brown.
Nice of you to finally speak up. Go ahead.
Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Ms. Schmidt, who has already introduced herself.
Yes, she has.
So this is the you hearing. We don't have any updated.
our office received a report.
I have a date. I have a report received February 19th, dated February 11th. Is that the one you're referring to?
Yeah, I checked our materials. As of yesterday, we have received it. We just got it yesterday.
We received it yesterday, yeah.
It's competent. That's true. So the finding is that my client is competent to stand trial. In which case, Your Honor, since we've had a chance to review that, has the court received that same report?
I haven't reviewed the same.
We have no further evidence.
All right. Any other evidence from the people?
Nothing on behalf of people, Your Honor.
All right. The court would find, based upon that report, that the defendant is competent to stand trial. Specifically, would indicate that the defendant can understand the nature and objects of the proceedings against her and can rationally assist in her defense. And so the defendant is therefore deemed competent.
Thank you, Your Honor. We will tender a finding and order to the court this afternoon. At this time,
I'm going to need 5 orders.
5 orders for 5 cases. Yes, sir. So at this point, we will to adjourn so that we can do a probable cause conference.
All right.
I think 2 weeks is the minimum you'll need.
Yes.
All right. So probable cause conference will be set for March 13th,
March 13th.
2025.
Does that mean I come back to court on the 14th?
Yes, ma'am.
And we'll talk to you in between that time.
We'll see you in a couple weeks.
Okay, I'll see you later, Mr. Cedric Johnson. You
All
are.
right. Bye.
My mama watches your podcast.
Okay. Yes, ma'am.
Bye-bye.
All my clients are that happy to see you.
I know. Yeah. It's nice to have
I'm
somebody happy to
sorry.
see. All right. Take care.
I'm dismissed. Can I go?
Yes, you can go.
You have a great day. Have a great couple weeks. See you in a couple weeks. Bye-bye.
You too. Court does call the case of the people versus Demetrios Masterostropoulos.
Ellison on behalf of the people, Your Honor.
Your Honor, Joe Simon, on behalf of defendant Dimitri, state your name when you get here.
Dimitris Mastrapostolis.
All right. Greek. He didn't even try, so.
Court noticed.
Yeah, I did.
Requesting the matter be set for preliminary examination, Your Honor, because I know the court prefers it, if it's possible to schedule it for the 25th of March. Prefers dates.
2 cases in. 2 cases in. First was slip and then second. Is all discovery complete?
It actually just finished being complete. Ms. Enda told me that she sent me the last part of it, so we'll be ready, yes.
Will the people have their witnesses available on the 25th?
We'll do our best, Your Honor.
Preliminary examination in person, March 25th, 2025, 9 a.m. That's before me.
Fantastic.
Yeah. Glad one of us feels that way. Bond will continue. All right, thank you. Court does call the case of the people versus Jeremy Anderson.
Counselor Lonnie for the people.
All done. You can wait if you want.
So as soon as you guys finish your conversation, Mr. Bernstein, you might want to join your client, I think.
My client. Oh,
That's who I have.
oh, okay. Walk over there then. Good to see you. All right, so we're here for Mr. Anderson, Your Honor. I did not realize that he had been scooped up. So I will have to ask for an adjournment of a week or two, please.
Need you to fill out a form when you get a chance. I'll adjourn the probable cause conference March 13, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Stephanie Serene.
Your Honor.
Your Honor, Joe Simon on behalf of Ms. Serene. State your name, Stephanie. And Your Honor, in this case, we're asking to adjourn the PCC a couple of weeks. There's some continuing negotiation. I'm supplying some information to the people. I don't think that request is going to be opposed.
Probable cause conference March 13, 2025, 9 a.m. Bond continue.
One other thing, Your Honor, regarding bond, the magistrate ordered at the time of arraignment, a curious order. My client's been testing for over 2 years through the HPRP program. This matter is quite old. My client has reported it to Laura. She's on probation to Laura. She's serving her probation and testing quite regularly for 2 years almost. In May, it'll be 2 years. So to avoid duplication of testing, the magistrate ordered that we turn the results over to the court, not to community corrections. So I have them. So I told the prosecutor that I would bring this up to the court because I think.
Well, let me just ask, did the magistrate order testing at community corrections and then do it that way?
No, and we tried to get these 2 community corrections. They said technically they would take it unless.
That's it. They're right.
So
how often is she testing?
every 2 weeks,
Sometimes weekly.
sometimes weekly. It's random, but it kind of averages out. I have 2 years of tests right here that I can give to the court.
I don't want to hold those. So here's what I'm going to do. I will order testing at community corrections. And it's Laura that's testing her.
Well, it's under Laura's supervision, but she tests that at a lab. That's not their own lab, is what I'm saying. But community corrections said that they would accept these results if she signed a release, which she's totally happy to do, but they needed this court to accept or order their supervision or something like that. Sorry.
Well, yes, what they want is I have to order community corrections testing and then permit the testing to occur at the facility.
Thank you.
And I'll order that. And could I get a community corrections order on this. It's just the frequency of the testing. Maybe you test approximately every,
I'd have to check in Monday through
This is a
Friday,
big
and it
deal.
will
A
tell me if I
conflict
have
of
to test
interest
or
could
not.
derail the
Got
entire
it.
case.
So
But since
what
it's
I'm gonna do
unrelated,
is I'll
the judge
order
is giving the
weekly
green light.
testing
For now, that's
through-
because courts don't like unnecessary
And
delays.
Mr. Simon, if you
If the
could-
defendant's okay with it, they keep the trial moving. Competency is huge. If the court rules the defendant isn't fit to stand trial, everything pauses until treatment restores competency.
So I've signed that order. And so I'll order that testing, and if you could get to, and the, testing facility and just put on there that she may test,
The name of this.
whatever the name.
It's usually like a. Yep. Urgent care.
I put,
It's through.
so it was there.
Yeah, yep.
What are these?
You're next. They're individual. I'm just
Got it.
working.
Okay. All right. All other respects, bond will continue.
Thank you.
Who's gonna adjourn to March 10th?
13,
13th.
I think. That file's long gone.
Yes, 13.
All right.
And tell me what
You're
what?
Court calls the case people versus Ashton Dew. You guys are gonna have to.
Pastor Lonnie for the people.
All right, thank you.
Thank you. For the record, Your Honor, Joe Simon, on behalf of Mr. Dew. Mr. Dew, state your name. Ashton Dew. Your Honor, in this case regarding the PCC, we're requesting an adjournment. The reason is my client was ordered through the circuit court for a mental health evaluation. Judge O'Brien signed an order, I think yesterday, or the day before. I was out of town. There was a petition requiring my client's evaluation. And I had a copy of that order. Ashley, that-
Well, when's the next date before Judge O'Brien? And I'll just go around that.
So, Your Honor, it's not clear. The evaluation is supposed to take place prior to the 8th, sorry, she signed an order for evaluation and transport for the jail to take him to the University of Michigan Hospital. And that's supposed to happen by March 8th. And I'll be doggone if I can't. You get that back, right?
I did.
I'll find that order and bring it to the court in a minute. But the point is, he also, at the time of his arraignment, was ordered because a mental health evaluation was being sought. The magistrate ordered that he could go to a mental health facility, but he had to first be tethered, a GPS tether. And the sheriff's department was waiting on the court today to see if, with the circuit court order, if that changes anything or not. And let me just, I'm probably just.
Judge O'Brien ordered that he be transported there under the supervision of the sheriff.
That's correct.
So there's no need for the tether, right?
And Your Honor, what I'm not clear on is he needs to be transported just for the evaluation
sorry.
or for evaluation and treatment at this point.
I believe it's the evaluation, and let me just find that.
So, all right. So the idea is he transported pursuant to Judge O'Brien's order, he'd be transported, go through the evaluation, and then come back to the jail.
That's my understanding, what I think should happen.
That's the order.
Yes, sorry about that, Your Honor.
No, it's okay.
Yeah. So as I read this, he should be able to just be transported, remain in police custody, go through the evaluation and return to the jail.
I think under the order, that is exactly what's supposed to happen.
And if
Because he's being taken there in protective custody.
if the court could do anything to clarify that for the sheriff in this file, because they were a little confused about that. Yes.
Want me to just say it out loud or what do you want me?
I mean, I don't know if you need to write something or something like that. but-
So I'll do it this way. That's at U of M.
Yes.
I think that's what it said, Your Honor. University of Michigan Psychiatric Emergency Room, yes.
Stated as artfully as they would. So I'll have his bond continue. I've written on the register of actions that defendant does not need the tether for transport to U of M under the Washtenaw County Sheriff's Office's custody.
Thank you. Thank you, Your Honor.
Deputies must remain with him and transport him back.
Well, they would according to her order. I mean, I'm not ordering that he go there. I'm just clarifying the tether portion of this order.
Thank you.
Your Honor.
Thank you.
What was the next date, Your Honor?
Did I give one?
I don't
I
think
don't know
so.
that we've got one.
You said that's going to be done on the 8th, but I don't
It
know
says
when we
honor
have a
court.
report.
Yeah. Yeah.
So I can do the 20th or 27th.
Hold on. Sorry.
20th or 27th. I
Um,
don't know when you think to go have a report.
That's a good point. Probably the later date, Your Honor.
27th.
Smarter.
Probable cause conference will be adjourned March 27th. You
Your
can't
Honor,
do that. It's spring break.
the 20th would be better for me, but thank you, Your Honor.
March 20th, 2025, 9 a.m. Bond will continue with that added condition. And you can tell Lisa's she's welcome.
Okay.
Court calls the case People versus John Cahill.
That's the money for the people.
And Your Honor, Joe Simon on behalf of Mr. Cahill. John, state your name.
John Cahill.
Thank you.
Your Honor,
We have reached a resolution in this matter. Unfortunately, Mr. Simpson was not able to speak to Mr. Cahill this morning when I informed him of the offer. It's my fault for letting Mr. Simon know this morning. I think he's going to request an adjournment, but we are there.
yes,
Apologize.
yes. Mr. Cahill does not even know that an offer that I think will resolve the case has been tendered this morning. I did try to call him, but as the court can see, his nephew is using the phone that I tried to call him on
Right.
to make the Zoom connection. So asking for a brief adjournment because I believe.
13th, you think you get it accomplished?
Oh, this, yes, I'm definitely.
Okay. Probable cause conference will be adjourned March 13th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus Nicholas Elka.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Elka. Your name?
Nicholas Helga.
Your Honor, we've been working towards a resolution that will ultimately save us from a lengthy preliminary examination, so I'm hoping for an adjournment to make that happen.
How much time are we looking at given?
2 or 3 weeks, Your Honor.
Probable cause conference, March 20th, 2025.
Thank you, Your
9
Honor.
a.m. Bond continue. Thank you. Court calls case People versus Ana Cardona Ramirez. Oh, my goodness. I mean, hi.
Good morning, Your Honor. Steve Tremontian with and on behalf of the defendant, Ms. Cardona Ramirez. Could you state your name for the record, please?
Cardona Ramirez.
Your Honor, there is a fully executed substitution of counsel in the file.
I've signed off on that.
Okay, Your Honor. In terms of the PCC, discovery is complete. We'd ask that the court set this matter for preliminary examination in person at the court's earliest date.
People have their witnesses available. What's my next name? 11. People have their witnesses available March 11th.
We'll do our best, Your Honor.
Preliminary examination in person, March 11th, 2025, 9 a.m. That's before Judge.
Your Honor, may I address briefly? Sure. Thank you, Your Honor. Ms. Cardonia Ramirez was placed on tether by the magistrate over a month ago. She did go to mental health treatment, inpatient, successfully completed that. She was released 2 weeks ago. She's been in total compliance of her bond. Obviously, the tether is creating a financial hardship. She certainly intends to follow all the other conditions of her bond and not go back to the marital home. We would just ask that the court remove the tether.
I don't need a response from people. I'm going to decline to do so at this time. I'm going to leave the tether in place, and certainly you can bring that up with Judge Falvo following preliminary examination.
Thank you, Your Honor.
Thank you. I'll need an order to. Court does call the case of the people versus Elroy Love. 3 cases.
Alexander, on behalf of the people, Your Honor.